Hi, it's Bill Gross, the LA probate expert, and today I want to do a short tutorial on the forms required when submitting an offer for a probate real estate transaction in the state of California. Now, the similar rules might play in other states. I'm not aware of any forms that other states have as requirements. California, I believe, is the only state that actually has such forms. And really, what I find is 95% of the questions I get asked on the procedures are already on the forms. And if you as an agent just take the time to read through it, you're going to be ahead of 95 to 99% of your competition, both in terms of writing offers as well as being able to list property. Let's go through and detail the forms and we'll talk about how we can be effective with them. Now, first thing I'm going to say is there's only 3 forms total in California for a probate. There's the probate purchase agreement addendum. Now, on the regular purchase agreement form, there's a box under property types for probate addendum. That would be checked and then would bring this form into play. After the addendum, there's attached a probate advisory, and that is another 2-page document that basically doesn't get filled out other than date, but lists a bunch of disclosures. We'll go through that. The only other form that California has is a listing form. We're not going to cover that today, but very simple. So again, on a purchase document, there would be 2 forms. If the probate agreement purchase addendum is checked on the residential purchase agreement, then this would come into play. And this addendum also brings with it automatically the probate advisory. So let's go through that in detail. On the top, obviously, you put in, this is going to incorporate as part of the purchase agreement. Now, it might be brought in by some other form, but 99% of the time, it's going to be the purchase agreement. You leave that blank. You put the date of the purchase agreement that you're either submitting it or it was created. And then you have the property address. I just put in 123 Main Street here to get something going, in which the seller, you would copy the name of the seller that's on the purchase agreement, even if it's wrong, because it's going to get addendum later, is referred to as the seller. It's important that on a probate case, you can have the name of the person who's deceased, or better would be the estate of the deceased person, their estate, because obviously that person isn't alive. Sometimes people write the offer with the name of the person on it, and if you already have that as a listing, as a seller, listing agreement, as a selling agent on the listing side, then you would reply and have to add this form in. You might have to refer the wrong name. But on the buyer side, you always want to find out who the owner of the property is and then put estate of and then those names. Okay, and then the name of your buyer. Now, let's go through step by step. Number 1, type of probate. There's basically, I would say, 2 types of probates. There's standard and there's special. Standard would be a probate decedent's estate. Somebody died, owns property before they pass, and now they have an estate that's determining who gets it. Or it could be a special type of probate. Handled in probate court in California are conservatorships and guardianships and receiverships. So if you know which it is, you would click the appropriate one. You might ask the listing agent, is it a conservatorship or guardianship or receivership? Oftentimes it's explained in the agent remarks in the MLS, or a simple text to the listing agent should give the answer. If you don't know, you would leave it blank, and it could be corrected down the road, but it's always best to find out. You would only check it if it's not a regular decedent's estate, but if it's something more complicated, maybe 3% of the time, it's a conservatorship, guardianship, or receivership. A conservatorship is an estate created for somebody who doesn't have the ability to make their own decisions, typically somebody who's either become mentally incompetent or physically incompetent, like they're in a coma. A guardianship would be somebody who's not competent because they're a minor child. Minor children can't enter into agreements. And so a guardianship is established by the court to make decisions for them. And a receivership would be an entity like a corporation that's in bankruptcy or can't make its own decisions. That's receivership. So again, you only check it if it's one of those. Otherwise, you leave it blank. Number 2, if the property is part of a decedent's estate, which most are, then either paragraph 3A applies unless 3B is checked. And you'll notice 3A has no check mark, 3B does. So if you don't check B, A applies. And we'll get into what those mean. Number 2, the probate advisory, say our form PA, is hereby incorporated. That is the form I mentioned called the probate advisory form. Probate advisory, say our form PA. It's actually attached in SkySlope and in DocuSign. So all this is saying is that form is included. It's an advisory form. There's nothing really to fill out other than the date. Now, as far as court confirmation, there's two possibilities. A, it's undetermined, or B, it's required. There really is no not required. Because if you read the fine points, we're going to go through it, even if you think it's not required, it might be if certain things happen. If you know it's required, you would check 3B. Let's start with 3A. If we don't know, or the agent says to you, oh, it's not required, or not required at this time, or I don't believe you're required. Seller shall deliver the written notice to buyer at time of acceptance or within the seller time frame if court confirmation is required or not. So if they say it's not required, they don't know, you can check either box, and then it's up to the seller to put it in writing, or the listing agent to put it in writing, whether it's required or not at that time. If, and this is the key part too, if the court confirmation is not initially required, notice of terms of sale is still necessary. And then if a beneficiary objects, the court confirmation shall be required. What that means is if, and this is one question you might want to ask to avoid this is, how many beneficiaries are there? If let's say, for example, husband and wife die, leave one child, no other siblings, the only person alive is the only heir, then he's not going to object to the sale. In fact, he can sign the form and it's not even required. But if there's multiple children, they might think everything's fine, but as soon as they send notice to the other heirs, hey, we're selling the property for $400,000, sometimes the other heir goes, whoa, 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 I thought it's worth $500,000. Zillow says it's worth $500,000. And so it's not required as long as all the heirs are in agreement. And so you might ask the question, how many heirs are there? Or ask for a copy of the filing. We'll have a list on there of all the heirs, and then you can see who's being noticed and who's likely, if not, to object, and if there's a history of objections or not. So again, until somebody objects, it's not a problem. As soon as somebody objects, it becomes a problem, and the solution might be now you have a listing that did not require court confirmation that now does. 3A3. If after offer is made, seller notifies buyer that court confirmation is required, or court confirmation becomes required as a result of an objection, then the buyer, within 3 days after delivery of seller's notice, may cancel the agreement and be entitled to return of any deposit paid. So if your buyer offers on the property and it's accepted on the basis there's no court confirmation, and then because of one of those objections, turns out it has to be, your buyer has the right to back out and get their deposit back. And it just say their deposit back, doesn't say less any fees. FYI. Number 4. If court confirmation is or becomes required, the buyer has not canceled, according to 3A3, then the court shall proceed to paragraph 3B. If you know there's court confirmation required, you would check 3B. Sales contingent on court confirmation, which is a court hearing that allows for open competitive bidding of the property. The minimum overbid price should be an amount equal to the accepted price plus 5% of that amount plus $500. So for example, if your buyer writes an offer, they're accepted at $500,000, it goes to court. The court would accept offers at 5%, $25,000 plus $500 more, or $525,500. The court should determine any further incremental overbids. And notice it doesn't say the court will raise by 1,000 or 5,000 or 1%. Every judge is different. I've seen judges vary at court on how they do the raises. There's no set rule. I get asked this all the time by prospective buyers. There's no set rule on how the increments go up. You just don't know until you're there that day. Can you jump up a bit? So let's say it starts at 525. You want to bid 540 to shut out other bidders. Some judges accept that to speed things up. Some don't. There's just no way to know. And then see paragraph 4 for terms. When court confirmation is required, this is paragraph 4, seller shall file a petition to confirm the sale of the property with the court. So what happens is you have an accepted offer, and then at some point the seller has to file a petition. Seller shall notify buyer in writing of the court hearing and the time and location at least 15 days prior to the court confirmation hearing. The broker recommends the buyer personally appear to protect the buyer's position in the overbidding. Now that really only means if the buyer would be open to bidding higher. If that's the best and final price, then there's no reason for them to show up. The California Probate Code may require legal notice to be published in local papers, which it typically does, advertising the sale. If the publication is required, the buyer understands the seller is unable to accept the buyer's offer until after the expiration of the period. So when you have a court confirmation sale, you have to file a advertisement in certain legal periodicals. And you can't, and it'll say, we're going to accept the offers. It's about 3 weeks after the publication date. So if you file, let's say on May 1, you can't accept offers till May 22nd. And the best thing to do is actually wait till the next day, the 23rd, so it's clear there's a day difference, not the end of the day. And buyers say, well, can't you accept my offer? Well, you really can't, because the court wants to see that you give everybody a chance until the day that you finally accept. And in fact, the sale can be invalidated if you accept ahead of time. In such case, acceptance prior to publication is voidable. So again, you don't want to be accepted before that date. If the court approves the sale of the buyer, all deposit money held on behalf of the seller shall be applied towards the purchase price. If the sale is not confirmed to buyer due to an overbid, buyer's deposit money less applicable costs, notice that, shall be returned to buyer. If the sale is confirmed by the court, so basically some escrows will charge you a couple $100 cancellation fee. If the sale is confirmed by the court, an order confirming sale to buyer will be issued by the court. The buyer shall have to pay the balance of the purchase price within 10 days upon receipt of the order. Seller shall not be obligated to sign escrow instructions or incur any escrow cost prior to court confirmation. So what that means is when there's a court confirmation, at that point, really you have a court-ordered form that's used and is now binding. The overbidders, that's all they get. They don't get a purchase agreement. They don't get the rights that come with a purchase agreement. For example, a walkthrough. As the buyer, you do have some additional rights because you've now confirmed that sale. Now, here's some important information also that should be reviewed. The purchase price must be 90% of the probate referee's appraised or reappraised value of the property unless exempt. Certain sales are exempt, most commonly by the LA County attorney, the public administrator. But generally speaking, and the judge can also exempt it for certain circumstances, but generally, the court will order a probate referee, which is like a drive-by appraisal. And if that appraisal, let's say, came in at $500,000, you cannot sell the property for less than 9% of that, or $450,000. Normally, you'd want to check with the listing agent that they've done the review, the appraisal. Sometimes they don't do it ahead of time, and then the appraisal comes in low and your whole sale falls apart. So you'll want to ask that question. Buyer may increase the purchase price to the minimum amount required or withdraw from the transaction and receive a refund of buyer's deposit less applicable costs. So if you do make an offer and it is accepted and they later come in with an appraisal and it's lower, you can either, and it's higher, you can raise your offer price or you can back out. But again, you get your deposit back less any cancellation fee. If the buyer defaults after court confirmation, the order confirming sale may be vacated. So the buyer can't perform after the bidding or after court confirmation. The sale is vacated. That may result in a buyer's forfeiture of the full deposit, which at that point is probably 10%, or any amount the court may determine to satisfy any deficiency of sale costs. If the judge is pissed at you, they could order other damages, costs or other losses by the seller. So you don't want to enter into that with the expectation that you're not going to close or you're going to negotiate or you need to get a lender approval. You want to go in with no contingencies at all. Number B, seller can remove the property from the court calendar if the buyer has not removed all contingencies at least 10 days prior to court confirmation. So some attorneys want to wait till you waive all contingencies and then they'll file the form. Some will file and give you time to waive the contingencies, and if you haven't, then they'll pull it from the file. And then local court rules may require that all contingencies be removed, which is how LA is. But some counties will allow you to have certain contingencies as a buyer, even at court confirmation. I've not seen that happen, but I imagine that's possible. 5 is vesting. The buyer intends to take vesting as this. You have to have the vesting resolved at the court date because the judge is going to order the sale in the name with the vesting. And so this offer says you have to have your vesting done after acceptance. It's also warning you that you should consult with appropriate professionals. But here's the key thing. You can change your vesting up until the court date. The judge will say, how do you want to vest the property? And then you give them the answer. This is an important point, often not understood. Number 6. Paragraphs for liquidated damages, mediation, and arbitration are deleted from the agreement due to the probate court having jurisdiction. So there's only one person who's going to decide what's fair. That's the judge. There's no mediation. You're already in court, so you don't need to file to go to court. You're in front of a judge on any disputes on a probate case. That's good news or bad news. My experience is good news, but you would know. As a buyer, they need to know that those the liquidated damages, limiting them to 3%, and the mediation and arbitration do not apply. And there's any other terms, you put them here. Now, down below has some information regarding the commissions, and this identifies that the court can override your commission, and that generally the judge is going to determine what the commission rates are. So let's read this real quick. In the event court confirmation of the sale is required, the buyer's broker identified in the agreement agrees to waive all commission rights in the event of a successful overbid in court by a different buyer represented by another broker. A lot of listing agents put this in their listing agreement. There's no need to, because it's here in the form. As long as you get the agent to sign it, that you, as a buyer's agent, if somebody else overbids you, you don't get any commission at all. If your buyer overbids, you do get paid the commission. If court confirmation of the sale is required, the court will determine commission amount. Even if your listing agreement says 6%, 8%, 10%, and they're offering the buyer's side 2, 3, 5, 10%, doesn't matter. The judge is going to have to award it. And there's limits. In Los Angeles County, you're limited to 5% of residential property and 10% on vacant land. And the judge is going to limit it to that. Sometimes agents will attempt to make a case why they're entitled to more, and the judge can approve it, but generally won't. Commissions are payable by the seller only if the sale closes. Seller is not liable for commission any broker or licensee who is directly or indirectly a purchaser. And this is another one. As an agent, you can't also be the buyer in this case. Now, you can have an LLC, so you have a corporation and an individual. But as an agent, you can't be both the principal and the agent. The judge will not award you the commission, and all the commission will go to the listing agent. And then, of course, by signing this, you're agreeing that this is part of the purchase agreement, as well as that brings into the probate advisory. Let's go real quick through the probate advisory, because that's attached and part of it. Number one is, this talks about how, in general, it's a different transaction. One, sellers are exempt from TDS, natural hazard disclosure, and mellow ruse. On a probate transaction, those forms are not required on the seller. Number two, earthquake guides. The seller is exempt from providing a homeowner's or commercial property owner's guide for earthquake safety. And three, smoke detectors. The seller is exempt from requirements of smoke detectors that they be operable. It's because the seller typically is not living on the property. As far as disclosures, though, they're not exempt from other disclosing information that would otherwise be considered prior deceit. So oftentimes the seller will say, I don't know much. Well, what you do know, you need to disclose. The seller is required to do a hazard report. Water heaters have to be properly anchored, braced, or strapped. The same company usually will check the smoke detectors as well. The lead-based paint, you're not exempt from the lead-based paint disclosure, which just basically tells the buyer to be concerned. Carbon monoxide devices, not exempt from that. Oftentimes sellers will say they're not going to pay for it. That's fine, but they have to be done before the close of escrow. There's a Megan's Law database disclosure has to be done. They're not exempt from that. Gas and hazardous liquid transmission pipelines are not exempt from that requirement. They're not exempt from the tax withholding from the buyers. So the buyer's required to fill out that form, and the fact that it's a probate doesn't exempt them from that. And then brokers, still a broker has to do an inspection. We call the AVID most commonly. And they're also obligated for the agency disclosure. And then lastly, all local laws will apply, whatever those local laws are. In terms of death, it's being sold without a TDS, but if the seller knows the place of death, which is on the death certificate. So I find the easiest solution is to provide a copy of the death certificate to the buyer. And then the buyer needs to make appropriate concerns. Stock cooperatives, there has to be approval if it's a stock cooperative, very rare. And then court jurisdiction, this explains that generally property is sold under the Independent Administration of Estates, or the IAEA, and where there's limited or full authority. And all that's discussed above in the disclosure form. But it says if only limited authority has been granted, the sale must be conformed to the court. If full authority has been granted, the representative must get notice of proposed sale to the devisees and heirs. So again, if there's no objection, it goes forward, but if there's objections, you're gonna have court requirement. This is restating what was stated above on the other document. Liquidated damages, the probate court is not limited. So if you have a deposit, normally in a real estate transaction, the most damages your buyer's liable to is 3% of the purchase price as liquidated damages clause. But in a probate court, the judge can require anything. If they think you added fraudulently, they can charge you really whatever penalties they want. My experience is they don't, but I've seen cases where the buyer acted fraudulently and then didn't come to court and pay the right respect, and the judge threw the hammer at them. I think he took all 10% of the money. Mediation does not apply because the probate court, and same with arbitration, the probate court will resolve the matter. So again, these are things that you should just read through. It took me here 20 minutes to go through both forms in detail. You can read them through in 5 minutes. And then what I do is I also reference the requirement for these forms in my listing agreement. And then I will send a copy to the agent ahead of time to hopefully encourage them to do this. I'm going to send them a copy of this video as a training tape. So if you have any questions, reach out to me at Bill Gross EXP in social media, or call me directly 310-210-0008. And it's important that we learn and use these tools. I think the forms are not cumbersome and administrative, but are great tools to help us be effective in protecting our clients, protecting our companies, and protecting ourselves. And I'm here to help you in any way I can. Thank you so much for your time today.